welcome to your Simply Titled Heroes episode 13. Today we have a very special guest. Special guest, please introduce yourself.
Hi, I'm Debbie Davids. I am underwriting counsel with WFG National Title. We are the underwriter for Simply Title.
Yes, thank you so much for being here, Debbie. Today we will talk about probate, and hopefully Debbie can answer some questions and clear up some confusion because this topic can be a little tricky. So to start, can you please tell us what is probate?
Probate is the legal process that takes place after someone dies, and it legally transfers title to the beneficiaries or the heirs of the estate. It is a court proceeding that takes place.
And can you tell us when we may need to go through probate versus when you do not have to go through probate?
Sure. So if you hold title as husband and wife, when the first spouse dies, no probate is needed. Title is automatically transferred into the surviving spouse. However, on the death of the surviving spouse, then you would need probate to determine who gets that property. Same way if you own title with joint tenants with right of survivorship. And it's important to have that survivorship language in your deed. If you just hold as tenants in common or as two persons with nothing, then it's assumed that you own as what we would say tenants in common, and on the death of each of you, you would need a probate to determine who gets those properties.
Thank you. And does it make a difference if you have a will versus if you don't have a will?
It can make a difference. As far as needing probate, it does not make a difference. However, once the probate is filed, if you have a will, we say if you die testate, and the property goes according to your will, however you directed it. If you die without a will, it said you died intestate, and there are Florida statutes which dictate how your property will be distributed to your heirs.
Okay. And can somebody just on their own go to the court and file the probate process, or do you need an attorney to actually do that for you?
While you can, it really is better to have an attorney because there are specific documents that need to be recorded in the court file and certain documentation, and there may be hearings that need to take place. So we do recommend you contact a probate attorney to handle the probate.
Okay. And do you know how long the probate process takes?
I really don't, since that's really in the court system and we're really on the title side. And also would depend on what county you're in. Each county, depending on how backed up courts are, will determine how long it will take. But I would probably count on 3 months for the probate case.
On average. So it's really up to the court's calendar and schedule.
Correct. And how complicated your probate case is, how many heirs there are, how many properties there are. So yes, there are a lot of factors that could affect how long it takes.
Okay, gotcha. Thank you. So, for example, say my parents pass and I have siblings. Do we all have to agree on the sale of the home?
No, you don't. So let's assume it was their homestead, it was their primary residence, and let's for this case say they didn't have a will. That would mean that the property would be distributed equally to you and your siblings. And let's say one of the siblings really doesn't want to sell. There is a process called a partition where the other siblings can all agree to sell, and you have someone else appointed to sign for the sibling who doesn't want to, and then their share of the proceeds would get deposited with the court, and they can come claim them. We would also use this if you can't locate an heir. Let's say you have a sibling who no one's talked to in the past 10 years. You can have the same situation as a partition action.
Okay, that's really good to know because we all know that life happens and not everybody and inside the family stays in communication, and then when there's a property involved and you have someone who passes, it can be a little confusing as to know, what route you need to take. Is there anything about probate that may be surprising to, the regular everyday person? They may not know that maybe they should know before they go and put their home up for sale, or the home that they have inherited?
Well, just a few things. One, there are some different rules with homestead property versus non-homestead property on who has the authority to sell. So that would be an important factor to know, was it the decedent's homestead? Another is, sometimes we come with disclaimers, and that's where someone says, I really have no interest in inheriting this property. I'm going to disclaim my interest. And they have to file a form. It has to have 2 witnesses and be acknowledged and be recorded. But the interesting thing with a disclaimer is I can't disclaim it and say, I don't want it, I'm giving it to you, Tiffany. A disclaimer, if you disclaim it, you are treated as if you predeceased the decedent, and therefore your share would go to your heirs. So we would need to find out who your heirs are and either obtain disclaimers from them or deeds from them. And I think people think that when they disclaim it, they can say who they want it to go to, maybe one of their other siblings. The other thing about a disclaimer is you cannot disclaim to avoid a large judgment. And we see that often where maybe someone has a federal tax lien. If the purpose of the disclaimer is to avoid that tax lien, that disclaimer is not valid. So disclaimers are popular, but you have to be cautious with that. One of the other situations we see is if one of the heirs dies either before or after the decedent. If the heir dies after the decedent, then we would need a probate on their estate because we need to know who gets their share of the estate. If they die before the decedent, then their share would go to the remaining beneficiaries. So that's also something we see frequently on where beneficiaries die, especially sometimes probate isn't done for several years, and you could have several of the heirs die in between.
Okay. So if you do have a family member that passes and you inherit the home, and you want to put the house up for sale because you weren't living there, you can't afford to take care of the upkeep and the expenses, so you want to get this house on the market, can you go ahead and have a realtor list that home and get into contract before the probate process is complete?
Yes, you can. You would, depending again if it's homestead or non-homestead, you may get an order from the court authorizing you to sell the property, and if you're selling it to a third party, you can go ahead and sell it during the probate period. Same thing with homestead property. If you get deeds from all of the heirs and an order authorizing the sale, you can go ahead and sell while the probate is still continuing.
And can you actually go through and complete the sale until the probate process is done?
Yes, in most cases you can do that, as long as you have the appropriate orders and deeds from the appropriate parties.
Okay, great. Thank you very much. So I hope this answered some of your questions. Thank you so much for joining us today. Thanks so much for being here, Debbie.
My pleasure, and if you have any questions, please reach out and we'll be happy to answer them.
Until next time.